So the undue influence, if the client try to give a hint for the auditor that he might replace him next year, this might be a threat for the auditor. So how can the auditor safeguard himself against the threats? First, by reaching out to the regulator, the professional standards, the hotline, the consultation lines that are available, or if the client has an audit committee, the auditor can reach out to the audit committee or the executive management and explain the threats. But the client safeguards by itself cannot usually reduce the threat to a good level. Usually, the auditor has to reach out to the regulator or lawyers or his audit firm and try to see his policy, the quality control process, and then evaluate the threat and try to take action against those threats. The next one is the integrity and objectivity. And what do we need to learn about integrity and objectivity? That the member should be objective all the time. What does it mean? The auditor, during his audit, should not have emotions towards the client, but rather than evaluating the facts as they are. The integrity shall be free of conflicts of interest. So the auditor, for example, should not have like a close family member in a key position of the client's company. So because this might create conflicts of interest. The auditor should not misrepresent the fact intentionally. So the auditor should be objective in representing all the facts of the client. Example about the conflict of interest, as I say, advertising or advising two competing clients to acquire the same company, or advising both the vendor and the purchaser in a given transaction, or representing both parties in a divorce proceeding. So you can tell from those examples that the auditor cannot take the position of two competing sides. He should stand for one side only. Advising client A in an attempt to purchase client B when the member is in possession of confidential information related to client B that is relevant to the transaction. So the auditor has to disclose his information or his information to the client before giving an advice. How to avoid the conflicts of interest? Conflict of interest, by the way, it's quite common that might happen in any situation. And the good thing is to disclose it and try to avoid it. Good example, the conceptual framework analysis should be applied. Number two, before we take the client, as I say, we should take reasonable steps to identify any conflicts that might arise during the audit. If something arises during the audit, the auditor has to disclose it, and the other parties affected and obtain the client consent, usually in writing, to make sure that there is no hidden agenda in the audit. Disclosure to client or others can be general or specific based on the judgment that might happen. So the good thing about the conflicts of interest that whenever it happens, the auditor is required to disclose it to the client. If client doesn't agree about what the auditor says, then the auditor should withdraw from the relationship. The director position, it's a big area that might create conflict. The member should not disclose confidential information about a client to the organization on whose board the member serves. So the auditor, we know that three that should not disclose the information, usually the doctors, the attorneys, and the auditors. They should not disclose their confidential information. Serving as a consultant rather than board member may be preferable. So we should not sit in the board of the client's company. Serving as a board member of a certain institutions like banks, for example, will likely create a threat because the banks, they give loans to the client, and by being a board member in a bank might give some preference to the client, which is not recommended. Gifts and entertainment might create also a big issue. And for that reason, the auditor is required not to take any gift except for like something reasonable and should not violate the members or client personnel. So for example, like taking like some stationery or something, this might be reasonable. I know reasonable, it's a big word, that whatever reasonable for one person might not be reasonable for the other. And this is the reason the auditor should disclose to his director any gift or any present that is given from the client to the auditor. It should be disclosed to his direct supervisor and get the approval whether he should take it or reject it, because this might compromise the audit quality in the long run. Applying safeguards cannot make what was otherwise unreasonable gift reasonable. So if it's unreasonable, it is unreasonable and we should not take it. The next one is misrepresenting financial statements or record. And we need to make or permit or direct others to make material false entries. And this happens usually at the year end. The auditor should not tell the management to make a wrong transaction to cover up a fraudulent act that might exist in the financial statements. This is what we mean by misrepresenting, trying to dress up the financial statements to make sure that the fraud is hidden. This is non-acceptable and the auditor should not do that. Fails to correct material misstatement. So if the auditor finds an error or a fraud, he should not ask the management to cover it, and he should disclose it, and he should not correct it. He should disclose it as it is. Sign or permit or direct others to sign documents. It's not the job of the auditor to tell the management which items they should sign or permit or do it containing false or misleading information. Applying safeguard is not an option here because the auditor has to say no from the beginning. Subordination of judgment. If member concludes that a position results in a material misrepresentation or violation of law, he should, number one, discuss it with his higher authority, like his manager. Determine if policy require additional internal reporting so he can escalate it to the beginning. Determine responsibility of communication with third party like attorney. Consider consulting legal counsel. Document the facts. So how the subordination happens? If the director or the supervisor of the audit process is a friend of the client, and one of the auditors in the team finds some fraud, so he might report it to his supervisor, but because of the relation between his supervisor and the client, he might tell the auditor to do something otherwise than it should be done. So what the auditor should do, if he cannot get it done through his direct supervisor, then he can search for internal reporting, like hotlines inside the audit firm that can take his complaint and examine it, or talking to the legal counsel of the company and make sure to document all the facts and even the emails. And finally, consider discontinuing the relationship, withdraw from the audit engagement, or withdraw from the client. Using the third-party service provider. So good example for that, if the audit engagement is so big, we might need third-party service provider, but before disclosing the confidential information to this third party, we need to get the approval from the client, preferably in writing, and get the permission from the client to do so. It's not required if the third party is providing only administrative support like record storage, software application, and so on. So this is in brief the first 2 points in the framework for the members. As we said, the first one is the conceptual framework. The second one, integrity and objectivity. And we will complete the rest of them in the coming videos. I hope you find this video useful. And if you need any more information, please let me know. Thank you.